Hello, Raya. Hello, Raya. Can you see us? Raya?
Candace, I can't hear you. I'm not sure if you're muted or something.
I can hear you.
You can hear me?
Yes, I can hear you. I can hear
All right, we'll get started then. So my name is Raya Mackenzie. I am an associate lawyer at Jawl Bundon LLP in Victoria, and I practice in estate planning law. It's a very broad area of law that generally includes wills, trusts, and what we're talking about today, which is incapacity planning. So I'm going to take you through my PowerPoint presentation that I have for you on planning for incapacity and what that looks like. So just bear with me a minute. I'm going to be starting to share my screen with you so we can get the PowerPoint displayed for you. Oh, maybe I can't do that.
You just need to be the co-host. All right. You should be able to share it now.
Should be able to now, okay.
Yeah.
Mm-hmm. Okay, so you should be able to see my PowerPoint here. So our first slide here is talk about when does incapacity planning happen? So incapacity planning is usually part of a larger estate plan. This would happen when you go in and talk to an estates lawyer like myself about what you want to happen in your overall estate. It can be confusing because the word estate generally refers to someone being passed away, but incapacity planning is part of estate planning. It doesn't really need to be, but that's the way that lawyers generally address it. So when you come in to meet with a lawyer to make an estate plan, there's two broad categories that you're going to be talking about with that lawyer. And that's what I've shown here. It includes what happens after you pass away, so wills and sometimes trusts. That's what most people think about when they think about estate planning. And I believe that another lawyer has given you a presentation on that before. And then on the other side, what happens if you are alive, but you're not capable of managing your own affairs? And that's incapacity planning. So that is what happens if you are, you get into an accident, you have a stroke, you have dementia, all of those things where you need help, but you are still alive. And that's what we're going to talk about today. So here's some key terms that I'm going to use in the presentation. Assets and property mean the same thing. Sometimes my clients tend to think that property means real estate, but property in the law just refers to everything that you own. So your assets or your property would mean your house, your bank accounts, anything that you own, your antique china, all of that is assets or property. The donor is the person who's planning for incapacity. That's the person. Hey, I'm giving a presentation right now. Apologies, everyone. Interruption there. So the donor is the person that's planning for incapacity. So that's, in this context, would be you. So you'd be the person deciding what's going to happen if you become incapable of managing your affairs. The attorney refers to a person acting under a power of attorney. We're going to talk about powers of attorney in a minute here. A power of attorney is a particular type of legal document. And in this context, attorney means the person who's acting under that document. It does not mean a lawyer. Some of my clients get confused because in the United States, the term attorney is frequently used to mean a lawyer, and that's not the use that is common in Canada because an attorney means someone acting under a power of attorney here. So that can be a bit confusing just with the interjurisdictional terminology. The term representative means a person acting under a representation agreement. And we'll talk more about representation agreements in a minute here as well. So those are the key terms that if you hear me say, that's what they mean. I'll try to make this as user-friendly as possible and use terms that people understand, but in case these are the ones that are here for you. So I'm going to talk a bit about why we plan for incapacity. Of course, like I think most people understand, it's important to have someone look after you if you're not capable of managing your affairs. But it is very important, even if you don't think it will happen now or soon, it's important to have these things in place. If you don't plan for incapacity, it can create complications for your friends and family, and it can cost money because the legal procedures that we need to do if you haven't planned for your incapacity are more expensive than drafting the documents that help you plan for incapacity. So that's one reason. And then the obvious ones, you want to make sure that you are looked after financially. If you become incapable while you're still alive, you want to make sure that you are taken care of by someone you trust. And similarly for your medical wishes, you want to make sure your medical wishes are realized if you become incapable of making those decisions. Those are the three main reasons why it's important to plan for incapacity. And to do it early, even young people, even young clients should generally have an incapacity plan in place, because we never know when we might get in an accident, we might not be capable of managing. Now I'm going to get into what documents are involved in incapacity planning. You've heard me talk a little bit about these already, but we're going to get into the nitty-gritties of what these are and what they mean. So there's the power of attorney, which is sometimes called a PA, and a representation agreement for healthcare, which is often called a rep agreement. A power of attorney is a document which appoints someone to manage your financial and legal affairs. And the representation agreement for healthcare is for medical decisions. So there's a division of those two aspects of your life in incapacity planning: your financial and legal affairs, so your banking, your rights in your house or property, all of those things are managed by a power of attorney, versus medical decisions, which are managed by your representative under a rep agreement. There can be some other documents associated with incapacity planning, mostly regarding trusts. Those are more complicated and are generally not needed for the average person, so we're not going to talk about them today. But there are other documents that you might be doing in an incapacity plan. But the two that are most crucial are the power of attorney and the rep agreement. So powers of attorney, important features. They are one of the most, if not the most powerful legal document. In signing a power of attorney, you are giving another person the power to manage your affairs as if they were you. You can restrict powers in a power of attorney. So you could have a power of attorney that would appoint someone only to manage your land or only to do everyday banking for you. That's possible. But most people want to appoint someone who can do everything that they could do in case they become incapable. So they're wanting a broad and general power of attorney, not a restricted power of attorney. And because they are so powerful and broad, it's very important that you appoint someone you trust who is going to be looking out for your interests 100%. The power of attorney ends after your lifetime. So I have this often where son or daughter of a deceased client will call and say, oh, you have to give me this, or you have to give me that, I'm power of attorney. And I say, that doesn't matter. After someone passes away, power of attorney, their authority ends. And the person who takes over from the power of attorney is the executor. So the executor, the person who administers your estate under your will, which I think you've already had a presentation on wills. So that is how that works. So power of attorney is only active while you're needing someone to help manage your affairs, but you're still alive. What does the attorney, the person appointed under the power of attorney, do? They assist you with your financial decisions while you're still capable, if you want them to. You don't need them to do anything. most clients make a power of attorney long before it's needed. So for example, a couple might have powers of attorney naming each other. They're not using them right now. Those powers of attorney just exist and they can use them if they need to. But most people don't start using them until an accident happens or dementia happens or a stroke happens and they need to start using them. Some people want to start using them while they're still capable, because it will ease the transition between managing their own affairs and having someone else do it. So for example, I have grandparents who have dementia. They don't have full dementia yet where they're not capable, but my mom, who's the power of attorney for them, is starting to help with their financial affairs while they're still capable, so that it's less of a transition for her and them when she takes over in that way. So that gets to the next point. They take over from you in financial and legal matters when you become incapable. And that can happen as a result of a transition. So they start helping you and then just slowly take on more and more responsibility. Or it can happen really abruptly if you get a stroke or an accident where you don't have time for that transition to occur. They can take over right away. So the attorney manages your money and your investments. They file your tax returns for you. They make decisions about your real estate, including if your house should be sold. They can make gifts and loans for you if it's permitted by the power of attorney document. So that's something I talk about with my clients quite a bit. What kinds of powers in terms of gifts and loans do you want your power of attorney, your attorney, to be able to make? Do you want them to be able to give any gifts and loans if they think that you would want to make those gifts and loans? Or do you want them to only make gifts and loans if it's something that you would normally do in the ordinary course of your behavior? This is an important one because sometimes your attorney, if you're incapable, is trying to make some strategic tax planning decisions for you. And so they're wanting to give gifts while you're still alive. But that can create issues amongst the family if those gifts are too large or not done fairly. So it's important that you address your mind to your family situation and what powers you want them to have in that way. Who should be the attorney? So who's the person that you should appoint to act under this very powerful legal document? So be someone you absolutely trust, someone you trust to only use this document when it's needed and when you've asked them to, or when it's required. It can, it's very important. I can't stress this enough, to trust your power of attorney, because they can go rogue. They can, if the relationship breaks down and you can't trust them anymore, they do have access to all of your finances the same way that you do, if they get their hands on the document. So important that it be someone you absolutely trust. It should also probably be someone who can remain collected when under pressure or in tragedy, because incapacity can strike at unexpected times, and it's important that this person is able to act coolly and proceed with making sure your affairs are in order. Should be someone who's financially savvy, someone who knows how to work with accountants, someone who knows how to work with your investment advisor, someone who knows something about managing finances. Also someone who understands you and your particular financial goals and what you would want with your assets. Fair-minded and avoids family conflict. This is important because the power of attorney, the attorney acting for you, could upset the family dynamics depending on what they decide to do. So if they decide that they're going to pay for a very expensive renovation to your home, that could cause difficulties within your other children or other family members. So it's important that this person that you appoint, this attorney, fair-minded, avoids conflict, and is going to do things in the best interest for you. Usually the person that is appointed is a spouse, child, niece or nephew, trusted friend, person that's closest to you, trusts you the most. It's ideally someone younger than yourself. In the ultimate instance, often spouses appoint each other as the first primary attorney, and that makes sense. But in the end, you're going to need someone who will be there when your getting on in years and can't manage for yourself, you've got someone younger who can step up. What happens if you don't have a power of attorney? So if you don't take the necessary steps to make a power of attorney while you're capable, your family and friends are going to have to make a court application called a comiteeship application. So they're going to have to apply to the court and prove that you're not capable of managing your own affairs and ask for a court order appointing one or two of them to manage your affairs for you. This is a time-consuming process and it's often expensive. It costs at a minimum about $5,000, which is significantly different when you compare the cost of making a power of attorney, which is generally about $200 in legal fees. So $200 versus $5,000, I know which one I would pick. This process also requires the assistance of lawyers and doctors because it involves the court, but it also requires evidence from medical professionals that you're not capable of making your own decisions for yourself. It's usually very stressful for the family. So it's possible, we can get through it. I've done these applications before, but it's better not to. It's much better to have a power of attorney in place with someone you trust, so we don't need to do this. We're going to transition from the powers of attorney to talking about the representation agreements for healthcare. This is the other document I talked about in the beginning. These documents appoints a representative to make healthcare decisions for you. Some people talk about them or think about them like medical powers of attorney. That's essentially what they are. You're appointing someone to have all of the powers to make medical decisions as if you could make them for yourself if you're not able to act. This is the only legally enforceable document for medical decisions in BC right now. You may have heard the term living will or advance directive. Those are some other terms for paperwork that you sign to demonstrate what your medical decisions are or would be. Those are documents that we used to do in the past before the Representation Agreement Act came into force and was amended in 2011, I believe. So those documents are good. They provide evidence of what you want, but they don't bind anyone to them. So if you have something like an advance directive saying, please don't administer a particular treatment to me under these circumstances, that's fine. But if the doctors in that instance see you and think, no, that doesn't make sense, I'm not going to follow that, there's nothing you can do against that. That's just their decision at the time. This agreement instead appoints someone else to make the decision for you. So instead of the doctor saying, not doing that, that doesn't make sense, your representative would say, you're not going to do that. That doesn't make sense. And that person has the authority to decide what is done or not done. You can also appoint a representative with like certain specific instructions to them for different treatments that you want or don't want. More commonly, it's more of a general blanket power to make any of the decisions that you could make, because most of us can't decide right now today unless we have huge medical background on what specific types of treatments we would want or not want. I mean, we can all have a general idea that if we're going to pass away anyway, we might not want to be kept alive by artificial means, but it's not usually common to know exactly what you want. But you can make a representation agreement very specific if you want to. Okay, the role of the representative. So similar to the power of attorney, the representative can assist you with medical decisions while you're still capable. So same as in the power of attorney, where your attorney might be going to the bank with you or talking to your financial advisor with you. It's common for your representative, if you want them to, as you get older, for them to go to the doctor with you, take you to medical appointments, know about your medical situation so that if they need to step in, they can do that. They take over for you and make medical decisions once you are incapable. They decide what treatments and surgeries you'll have if you're going to have them and those types of risks associated with that. The big one is that they decide if you will be in a care facility and what care facility you will be in if you are incapable of making that decision for yourself. The final thing they do, I want to just note here, the representative cannot consent to medical assistance in dying on your behalf yet. I say yet in brackets. So some of you might be aware of the new legislation for medical assistance in dying, which allows a person to have a medically assisted death on their own choice by doctors. So if you are ill and you're terminally ill, you can decide to end your life at a particular point because you don't want to continue with suffering of the condition that you are in. This currently is only available if you have capacity, you're capable of making that decision on that day. You can't consent to it in advance. So you cannot say to your representative, if I am having severe Alzheimer's, I can't recognize anyone, and I'm suffering, I want you to consent to a medically assisted death for me. That's not possible. Your representative just doesn't have the legal power to do it. I say in brackets yet, because I think it's coming. I think there's already been some revisions in the legislation which allow people to make the decision slightly in advance. They still have to have capacity when they're making the decision. But instead of having, so recently you've been able to make the decision about 10 days prior. So you don't necessarily have to have full capacity on that day anymore. We're having slight time gaps in making the decision and having the medically assisted death. So I think that will continue. I think, though, it's going to have to be very specific to the representative on how and when that would occur. So likely not some sort of blanket statement that if you think I'm suffering, give me a medically assisted death. I think it's going to have to be much more specific than that. But I can't tell you for sure because we're not there yet in the law. But that's just something I flagged because many clients of mine have asked me if they can put that in the representation agreement, that their representative can consent to a medically assisted death. And the answer is they can put it in the agreement, but it's not legally enforceable. We can't do that. Who should be your representative for healthcare? So someone you know and trust with your medical information. So like with the power of attorney, this should be someone you trust, that you know that you can rely on. They know you well and your wishes for your healthcare. And again, like the power of attorney, able to make difficult decisions under pressure or in tragedy. This is probably more important for the healthcare representative than the attorney, because this person has to make decisions very quickly in hospital situations where life and death are on the line. So that's a lot for a person to be able to manage. So you want someone who's going to be able to do that. They're geographically close to you because they're going to be needed to attend at the hospital or healthcare facility where you are. They want to identify the person with their ID. They don't like taking instructions for people over the phone. It can be done, but hospitals are getting much more strict about when they will take the instructions from the representative. So it should be someone that is close to you geographically that can get there if you are in a health crisis. Similarly, it's usually your spouse, child, niece or nephew, or a trusted friend. And again, ultimately, it'd be ideally someone younger than you. So someone who can be available to make those decisions for you if you need them. What happens if you don't have a healthcare representation agreement? This is not as dire or as difficult as a power of attorney because the legislation allows the healthcare provider, so the doctors and nurses, to look for a substitute decision maker. This will first be your spouse. So the first person they'll look for is your spouse. The second will be your adult children. And then after that, any other relatives, nieces, nephews, and then friends, close friends. The problem with this model is it may not reflect your wishes or it may lead to disputes in the family. So if all of your adult children are your substitute decision makers, what if they can't agree? Or what if only one of them can be reached at a particular time? Your wishes might not be realized in the way that you wanted. Also, comiteeship, the expensive court application that I talked about earlier, that still might be required because hospitals and healthcare providers are getting more and more strict about having these representation agreements. So unless it's a truly dire situation where they need a decision now, they may not look for a substitute decision maker. And they may say, nope, we're not comfortable. We're not comfortable taking instructions from your husband, even though you've been married for 50 years. We want a comiteeship application to prove that he is the right person to make this decision for you. So that's not so great and is making these more important than they have been in the past. They're not quite as bad as not having a power of attorney because there is a possibility for someone to make the substitute decision, but it's something now that hospitals are getting more and more strict on it that I am recommending my clients have. In prior days where hospitals were less strict, I would sometimes say, your husband and wife, you have the power to make these decisions for each other, save yourself the $200 and you don't need one. But now I'm saying, still have one because some of my clients have been rejected of making decisions for their spouses of 40, 50 years, and that's horrible. I'm going to talk about some common models of how clients or someone like you might make an incapacity plan. These aren't, for everybody, but this is a very common option. So it'll be a couple that'll come in and see me, and they'll first appoint each other as the primary attorney. So in the event that one of them becomes incapable, the other spouse will be the first to act on behalf of the other spouse. It's very common. And then each of them appoints the most financially astute child, or if they don't have children, niece or nephew or close family member, to be the secondary attorney if the first spouse can't act. So the spouses have each other first, and then this backup person, the secondary attorney, to act in the event that they can't act for each other. And that secondary attorney is usually the person who's younger than them. So child or niece or nephew is quite common. It doesn't have to be the same secondary attorney for both spouses. This is very often the case in a blended family. So if one spouse has kids from their first marriage and the other has other kids, they might appoint different people. She might appoint her daughter from the first marriage and he might appoint his daughter from the first marriage. So it doesn't have to be the same. The couple then will appoint each other as the first representative, so the healthcare decision maker as the primary representative. And then same thing, they'll appoint a medically astute child or niece or nephew to be the representative if the other can't act, so the secondary representative. Again, doesn't have to be the same. So this is commonly what people do as their basic incapacity plan. I'm going to talk about some common pitfalls or obstacles in incapacity planning. These are things that I have encountered in my practice and that my more senior colleagues have encountered in their practices as well, just to alert you to what might happen and to be aware of these pitfalls. So the first one is can't locate the originals. This is very important, and it's strange that in this information digital age, original paper documents are so important, but they really, really are, especially for the power of attorney. The document that creates the power of attorney, without that original, you can't do much. You need that original to present at the bank, to present at the land title office, you need it. So make sure that it's in a safe place and that your attorney and your family know where to find it. Lawyers often offer to keep the power of attorney, the original, in their vault at the law firm for you. Up to you whether you want to take that option or not. I find that we don't lose it. We have a very good indexing system. We know where it is, and that might be your safest bet to making sure you know where the original is. The only issue with it is really making sure your family knows that it's at the law firm, where it is, and how to get there. People can keep them at home, and they often do, but again, don't lose it. Put it in an important box where you keep your paperwork. Let your trusted people know where it is. If you can't find it, it's a problem. If you can't find it, we basically end up having to do a comiteeship application, even though you have a power of attorney, because we can't find the original. So this is something that doesn't seem like it should be an issue anymore, but it is. So alert to that. The next issue is also common is problems at the bank. So when your attorney is going to start acting under their power of attorney and managing your financial affairs for you, the first step is often going to the bank with that original power of attorney, and the bank is going to validate it. So the problem with this is banks are sometimes a bit obtuse and they don't understand what they're doing. So they might have some kind of problem with the document. They might not know what it is. They might have to send it back to a different department in the bank. All of that can take time and cause delays. Or if there's something slightly wrong or different about the power of attorney, it can cause a lot of problems for the bank. The biggest one of this is names. So your power of attorney should have your full legal name on it and the full legal name of the person you are appointing as your attorney. But if there's a discrepancy in the names, which some people have, like I've seen commonly where you might go by your middle name, but you have a first name, but you reverse them on the power of attorney because you always go by your middle name, so that's how you think of yourself, and you don't tell your lawyer that that's not your legal name. That can cause problems at the bank. So it's a good idea, if you have time and it's possible for you, to have the power of attorney validated at the bank while you're still capable. Most people decide to do this when they're getting on in years. They want their representative, their attorney, to start helping them with their financial matters. Maybe not right away, but in the foreseeable future. So they'll go to the lawyer's office, they'll get the power of attorney, the original one, out of the vault, and they'll go down together, have their ID verified, have the power of attorney verified. So then you know there's not going to be any problems when you actually need to use it. That's not always possible. As I say, incapacity can happen at any time, but if it is possible, that is a good thing to do. The next problem that happens in incapacity planning is geographical or availability issues. So if your representative, your healthcare decision maker, or your attorney, your financial decision maker, are not available to make these decisions for you or be there when you need them, it can create a problem. Geography is a big one because, especially with the pandemic, where people are not able to travel to the location where they need to be. And this has become, it's difficult because the banks and financial institutions and medical establishments have quite strict policies on ID. They want to see that person in person. They want to know that it's them. And so that can be a problem as well. So there's no real way to solve that other than appointing people who are close geographically and can become available, or letting them know it's important that you actually be there. So, you know, if you're going to appoint your son who's in Toronto, alerting him, I've appointed you. Hey, by the way, if something happens, like, you probably are going to need to get on a plane and be here physically. So that can be a problem too if people are not able to attend. A next one that occurs is if your medical professionals are not aware of the representation agreement. There's no, I wish there was, but there isn't. There's no secret network of lawyers and doctors where I can upload your representation agreement and your doctors all know that you have one. That doesn't exist. So you need to tell your medical professionals that you have a representation agreement and that someone is named. It's important to do that because medical decisions can happen quite quickly, and if they don't know who they're looking for, it can create confusion and delay. So similar to having the power of attorney validated at the bank while you're still capable, good idea to let your medical professionals know about the representation agreement and see a copy of it while you are still capable as well. Another pitfall that can occur is family conflict. So if your family does not get along, there can be a lot of conflict between the people who are representing you, your attorney, your medical decision maker, representative, and the rest of the family. So this often arises, as I think I talked on earlier, where the power of attorney wants to take certain steps to maximize your tax planning or give gifts to certain charities or certain family members, and the rest of the family doesn't. Or some of your family members want you to undergo a particular procedure or live in a particular care home, and the others don't. This can be difficult, even in families that generally get along. So if your family is a very contentious family, you might consider appointing a neutral party. So this would be someone else, a friend, relative, who's just not involved in that part of the conflict. For example, if you have 3 kids and 2 really don't like each other, it might make more sense to appoint the third who doesn't have that same hostility. Neutral party sometimes ends up being a lawyer or an accountant, because these are professionals that have a lot of trust and who generally get to know their clients over the long term. So I have a couple clients who I'm power of attorney for in the event that they become incapable. And that's because they don't have someone who is able to act in a neutral way. I also have some mutual clients with accountants, who the accountants are their powers of attorney, so that if something were to arise, that's the person that would step up. Note with appointing professionals like accountants and lawyers, we generally don't like to do it unless we know you quite well, because there's a lot of work involved in it, and we will charge for we'll charge fees for it. We usually charge an hourly rate, so it can be expensive to appoint those professionals, but for many people, that's what they choose to do. The last point I'll make is, unfortunately, a pitfall that we don't really have a solution to, which is called falling into the gray zone, which is what I call it. This is where you still have capacity, technically, but you're at odds with your power of attorney or representative. And this happens because incapacity, medically speaking, is not a is or isn't capable situation. It's not that you have capacity one day and then the next day you don't. It's a slide from having capacity to not having it. And over the course of that time, there can be a gray zone that arises where you have some capacity, but you don't have enough to make decisions in the way that you normally would. So for example, someone might have always done their investments in a particular way. They may have always would have acted in a certain way in getting those investments out and doing their tax planning. And because they have incapacity issues, they're starting to get dementia, they suddenly don't want to do that and are putting up resistance to the power of attorney. And they're saying, nope, I don't want to do that anymore. I had a client recently who he has dementia and it's getting worse, and he's not able to remember what he said on one day and then he said on another day. And so it's becoming difficult for the power of attorney and him to manage his affairs when he still sort of has capacity. And the difficulty here too is doctors are not super keen to give letters or authorities saying that someone doesn't have capacity. So for the bank or any institution that's looking before them at, you know, an elderly client and their child who's the attorney, and the elderly client is saying, no, I don't want to do that anymore, and the child is saying, well, you've always done this, why suddenly the change? The bank is caught in a very tight position where there's liability for the bank either way that they go. So in that gray zone, really the only solution is getting doctors to give medical opinions, which can sometimes be like pulling teeth. Or if really, really needed, there can be a committeeship application. So the court application that I talked about earlier, that can happen even though there is a power of attorney and representative agreement in place. That can still happen because we just need full legal confirmation that this person can't make their own decisions anymore, in order for the people they've appointed to fully step up and do what's best for them, because the person can't look after their own interests anymore and are hostile about it. Happens more often, unfortunately, than I would like. So if you're thinking about your own situation and what next steps would be for incapacity planning, it's important to consider your own particular situation, your assets, your family, what's your life like. And talk to your family and your spouse if you have one in particular. Spouses are generally the first step in incapacity planning. Next step is to consult professionals. So talk to your lawyer. If you're close to your accountant, sometimes they have some good tax planning advice that you want to keep in mind. Talk about what this would look like. Once you've made a plan and you know who you're going to appoint, it's important to talk to the key players, so the attorney, the representative, let them know what their role is and where to find the documents. And then reconsider your plan every few years as your circumstances change. And you might not need to ever change it. It might be that your family is the same and everything just the way you want it. But it's important to reconsider if changes happen with geography. So if one of your children moves away, especially if it's very far away, you'll want to reconsider whether it's better to appoint a different person to take over for those appointments. Okay, so that is my presentation today. I hope you found it informative and not too dull. If you have any questions, I'm happy to answer them.
Thank you very much, Raya. It was really very interesting. And normally what we do is we ask people to write their questions in the chat box so that we avoid too much background noise. So if anybody has questions, please write them in the chat box. And Raya, I'm sure we'll answer them. Can you see the chat box, Raya? Raya? Are there any questions, anybody? Oh, somebody has a question. Thank you for the presentation. Raya, can you see the chat box?
Okay, I am muted, yes.
Okay, what is your question?
In regards to the power of attorney and the representation agreement, besides a secondary representation, can you
I'm unable to hear Candace, so I'm not sure if, I don't think there are any questions.
No, there is questions. There is questions.
There is.
In the chat.
Oh, okay.
Let me see the chat here.
Not sure why you can't hear us.
My bank is asking for a POA specifically for them. Is this normal? I thought the power of attorney was a general document. Yes, you're right. The power of attorney is a general document. Any lawyer can draft a power of attorney. Some banks are very, very particular about the way they want that power of attorney to look. This is becoming more common for banks to say, I don't like the usual way this looks. I want this to be very, very particular. If your bank is asking for that, you can say, all right, can you please provide me with an example of what you want this to look like? Take that to your lawyer and say, can you do it like this? And they can. It's annoying for us, but we will do it. If you already have a power of attorney and the bank is just being a pain, push back on them. They do not need their own particular form. It's a power of attorney. And you know, we can threaten them a bit with court order and things like that to make them recognize the document. But I'd say if you've already got a document that you want to use and you've already paid good money for, push back. If you are making a power of attorney and your bank has particular wants or needs, have your lawyer make it in accordance with their wishes to avoid any conflict in the future. Someone asked, will the slideshow be available to us? Yes, I have the slideshow. I sent it to Candace and Anna so they can provide it to you. I will warn you, it has a lot of my notes in the slideshow, which are somewhat colloquial. I don't know if you've noticed, I tend to just sort of speak more off the cuff. So don't be offended by my notes. I don't think they have any swears or anything, but they're not drafted in beautiful legalese or anything like that. All right, where are we? If no relatives or young friends or people I trust that don't involve conflicts of interest, what would I suggest? Okay. The first thing I would suggest is to look for a professional that you trust, if you can afford it, to act for you. If you have a lawyer you really like that you worked with a long time, or an accountant or a financial advisor, that is a good idea. That's the best first stop, because they are trustworthy and they are neutral. That's not the best if you don't have the funds to pay them, because this is a lot of work. We can't do it for nothing. So there's ways you can work out a deal. You could say, okay, well, would you lower it because it's me? Or, there's ways around it. But if that's not an option, the next step is, unfortunately, an institution called the Public Guardian Trustee. And that is the governmental body that takes care of people who don't have anyone to act in these positions. It's not something you probably want to do, but you're not going to be left high and dry. Someone is going to stand up and take care of you if you can't do it for yourself. Public Guardian is quite bureaucratic and does take fees as well. So not ideal, but don't worry, you will not be abandoned. Can you have a third, next question, can you have a third person along with a secondary for power of attorney and representation agreement? Yes, you can. You can have as many as you want. It does get more complicated and more expensive for lawyers to draft those documents, because there's just a longer chain of documentation that we have to draft to do that. But yeah, you can do that. Easy enough. Just be prepared that your document may look longer and your lawyer may charge you slightly more for that. Is the representation agreement something new? Would I need to get this RA written up and separate from my will and power of attorney? Yes. It's not super new, or maybe it is it's about 2011 is when the legislation for the Representation Agreement Act came into force. So 2011, I guess it's 10 years old now. I tend to think of everything after 2000 as slightly new, but yeah, so it's a separate document. So you have an estate plan these days is 3 documents: will, power of attorney, representation agreement. I am enduring power of attorney for my father who's incapacitated. His bank has treated him very poorly, renewed his mortgage midterm at a higher rate, and I would like to move his accounts. All financial institutions say they won't open an account for him unless I am his committee. Any advice? Yes. My advice would be so that power of attorney is valid. Unless there's something I'm missing here, your power of attorney, you have the power to do anything that your dad can do in relation to his financial affairs. It sounds like you've already been pushing back against the banks and saying, no, I can do this. Like, what are you doing? If you've been pushing back and they are not responsive, it might be a good idea to get a lawyer involved at this point. They can write some angry letters or angry phone calls to the banks and say, this is just bogus. They also can obtain a court order for you to have the power of attorney declared as valid and force the banks to acknowledge it. So that is sometimes more financially savvy than going through the full committeeship application. And definitely it's easier than involving doctors in a committeeship application. You'd want to talk to a lawyer about which will be less costly, and it would depend on what that power of attorney says. So without actually looking at it and being able to tell, I don't know, but it looks to me like they are being pretty bad. Oh, the POA is acknowledged. I just can't get another bank to open an account. General enduring, no limits. Yeah, you should be able to open an account with a general enduring power of attorney. So again, like they are being not right. Not that you should be allowed to do that. Again, you could get a court order. It sounds heavy, but you might have to obtain a court order to force the bank to do that. Someone is asking, yeah, thanks. Someone said, you are so right about banks. Yes, I am. I know they are horrible. And I've had many clients say, Raya, can't you just pick up the phone and yell at the bank? And I can, but it doesn't make the bank do anything. In order to actually force the bank to do something, sometimes you have to get a court order or threaten a court order and say, if you don't do it, we're going to get a court order and we're going to make you pay the fees because it's your fault for being so ridiculous. Okay, I saw another question. What would the fees be? Okay, I'm assuming you're talking about the fees for doing these documents. It varies. I am probably on the cheaper end of this, but typically it will cost between $150 and $300 to do power of attorney and representation agreement. So for each one. So I do deals where like I group it. So like for a couple, I have certain packages that I do where I'll say, I basically kind of do a 2-for-1 where I'll say it's going to be $300, but for all of you. So you get within that for both of you. Fees for legal management. Okay, so yeah, that would be the case where you are looking for a power of attorney to be a professional. That generally costs the professional's hourly rate. And it depends on how much time the professional spends. So for example, my hourly rate is $250 an hour. For most power of attorney management, I spend probably 1 to 2 hours a week. So that's about, $250 a week, depending on the amount of things that you need. Though for that one, that example I'm just using, I'm also the representative for healthcare. So if I were just the power of attorney, it might be less than an hour a week. It might be more like half an hour a week, something like that. But basically what I do, I'm paying her bills, making sure her investments are all right, planning for her tax returns, those kinds of things. And I also do her healthcare. So, making medical appointments for her, that kind of thing. So for her, I probably spend, about an hour or two a week, but it could be less depending on the circumstances of the person and if I'm doing healthcare or not doing healthcare. Sometimes the professional you're working with will not do an hourly rate, but will say, okay, how about it's this much a month, and just whatever, like doesn't matter like how many hours I spend, but I'll charge you whatever the case may be. And then and that can be a better deal, because if you're in a crisis and they have to spend 20 hours that month, it's the same. And then there are some months, where they might not spend as much time, but it depends. We're a bit resistant to taking on these kinds of appointments because there is a lot of liability for us in terms of the family getting upset with us and causing problems down the line. So we want to make sure that we're covered and compensated. And we'll generally do it for clients we like and really care about. It's a harder sell when it's someone we don't know, because not only do we just not have the same personal connection with them, we don't know what their family's like. So that's a big one that professionals are kind of worried about. So if you do feel like you want a professional to be either your healthcare rep or your power of attorney, and you don't know them that well yet, make sure you're upfront with them and you disclose what's going on in your family, so that they're able to decide how to take on that appointment in the best way possible. It's a hard job for if you're related, hard job if you're not.
Thank you, Raya.
Okay.
Thank you very much.
It sounds like there's no more questions. Everyone else is just complimenting me on my presentation. So thank you very much for your lovely compliments. Thanks so much. It can be a hard job sometimes. This is not the only thing I do. I do you know, other kinds of other areas that aren't as complex. Yeah, it's a hard job. And I am glad that you enjoyed it. And oh, to contact me. If you would like to contact me, my information is on the final slide of the presentation, which will be sent around. And you can contact me that way if you want more particular assistance. Okay.
Thank you. Thank you, everybody, for
Thank you, everyone, for
participating.
coming. And
Really appreciate it.
best
Thank
of luck
you.
in all of your planning.
Thank you. Thanks, Raya.